also part of the causes for the war. So new gas fields were discovered just off the coast of Crimea before Russia intervened in 2014. Second, crops and other supplies have been shipped from occupied Ukrainian territories to Russia, or moved, not only shipped, depriving the local population of crucial means of subsistence. And third, Ukraine's natural environment is also a victim of the war, with certain long-term consequences for the local population. So these are sober times. Now, fortunate for us, we have the benefit of 3 distinguished commentators on the book. Astute commentators. They will each in turn speak for about 10 minutes. And I'd give the floor to each of them in turn, and then moderate an exchange, drawing in the author, of course, and also all of you. Thank you so much for joining us on a Friday night. So the high opportunity costs, and it's testimony to the quality of the work, the book, the commentators, and the community that we have here at the Asser Institute, may I say also at the University of Amsterdam, that you come here and join us. Thank you for that. So we open that discussion, of course, also to draw in your views, comments, and so on and so forth. So the first in line would be Judge Charlesworth. She is a law professor at the Melbourne Law School, and also a distinguished professor at the Australian National University. She's had research grants from the Austrian Research Council Federation Fellowship and a Laureate Fellowship. She's well known, and her work also figures, her well-known work in the book quite prominently, rightly so. For instance, through her argument, or with her argument on feminist approaches to international law, and her work writing against thinking about international law only in response to a crisis and what that does to our thinking. And of course, Judge Charlesworth is a judge around the corner at the International Court of Justice. She would be followed now by Sophie Stalk, who is a senior researcher here in international law at the Asser Institute. And just a couple of weeks ago, we launched her book, part of a trias, on the opening statements of the prosecution in international criminal trials. A Solemn Tale of Horror is the title. It was published also last year with Routledge. Marilyn Petersman will be third in line. She's a postdoctoral researcher working as part of the constitutionalizing in the Anthropocene at the Tilburg Law School. She was a postdoc fellow funded through the Swiss organization at the Copernicus Institute for Sustainable Development at Utrecht University before, and her book is forthcoming. So be back, yeah, in a couple of months with COP. It's forthcoming under the title "When Environmental Protection and Human Rights Collide: The Politics of Conflict Management by Regional Courts." Eliana Cusato will have the chance to react, of course, and participate in the exchange. Obviously, she is at the moment still a Marie Skłodowska-Curie postdoctoral fellowship with us at the University of Amsterdam, and will be an assistant professor as of 1st of January, I believe, right? Yes, still at the University of Amsterdam at the Amsterdam Center for International Law. We are launching her book today, of course. My name is Ingo Venzke. I'm a law professor at the University of Amsterdam, where I also direct the Amsterdam Center for International Law. So it is without further ado that I would ask you, Judge Charlesworth, to start off the round of comments. Does that sound all good? Questions, concerns? Ready to go? Okay, the floor is yours. Thank you.
Thanks very much, Ingo, and thanks to the Asser Institute for organizing today, and to Eliana for inviting me to speak. I think, encountered Eliana in Melbourne in Australia. So she's, it's a great pleasure to see her, not really in her completely home environment, but a bit closer to home than she was when I first met her. I was thinking as I was coming here just how book launches, and I'm pleased to be, I don't have a book to launch, I feel quite, just you can watch out for judgment or two. Yeah, I think it's one of the nicest rituals to me of academic life. And it's a great honor to participate in this event. And I think these wonderful rituals are something that I've missed very much in my new role. It has its own rituals, but they don't include book launches. And apart from, obviously, it's a focus on Eliana's book, but it's a great pleasure to be here with my co-panelists, with two young scholars whose work I admire. So we've been given a very free hand. That's always dangerous, I think, in our approach to Eliana's book, but the instruction is not to take more than 10 minutes. So as Ingo has already said, Eliana's book is it's a wonderful book. It's a thoroughgoing critique of the international legal approach to nature, and her argument is that it's essentially an instrumental one. And I was thinking in the past few days what angle I should take on it. So there's so much in the book, and I think you can use it in a whole variety of ways. So on one hand, I think it's a very useful expert analysis of the international legal principles relating to protection of the environment in times of armed conflict. So there's that element to it, but it's also a really nice account of the significance of work of scholars such as Rob Nixon and Johan Galtung on slow and structural violence, the idea that appears in the subtitle. But as Ingo's already foreshadowed, one could also just focus on its very elegant modelling of interdisciplinary scholarship and the really wonderful ability that's displayed here to draw from political and ecological theory to illuminate the limits of the law. A bit that I really liked and that I thought was, to me, very illuminating was Eliana's, those of you who've had a chance to look at the book will know she juxtaposes the accounts of nature in times of war and peace by different types of institutions. There's international courts, the UN Security Council, and then a part I really enjoyed, which was on 3 different truth commissions and how they approach these work. But I just thought for my focus today, since I read anything I can about past cases of the International Court of Justice, where I am for the moment, I thought maybe I'd just discuss Eliana's account. She looks at 2 cases in particular. One is the 1996 advisory opinion of the court on the legality of nuclear weapons. And the other case that she looks at in some detail is the so-called armed activities case, a case where the judgment was handed down in 2005, a case brought by the DRC against Uganda, which raised, among a whole lot of other things, the question of Uganda's responsibility for environmental damage in times of armed conflict, and that caused by Uganda's military intervention in the DRC. What I was struck by was, and I think I read these with new eyes now, Eliana's highly critical approach to these 2 opinions. So those of you who've looked at the advisory opinion on nuclear weapons will know that the court found that the protection of the environment was just one factor in determining what was militarily necessary on the specific issue of the environmental impact of nuclear weapons. So I think it's fair to say that the decision has been, well, as Eliana notes, it's been praised by some, particularly Marty Koskaniemi, as a brilliant stroke. What else could the court do? Really, it had to disappoint, because otherwise it was going to be drawn into some ghastly legal opinion. But it's fair to say there's quite a critical literature of the court, of the advisory opinion there. And Eliana very much situates herself as a critic. She calls the opinion sort of convoluted, but also enshrining, and these are her words, a narrow and orthodox understanding of the idea of security. And as for the armed activities case, Eliana describes the judgment as conservative and minimalist, two adjectives she uses, reinforcing the view of nature as a resource that's subject essentially to property rights. And she makes the case, reading that judgment closely, that the court was valuing nature for its economic function alone, losing sight of its inherent value and its role in sustaining planetary life. So she also, and it's fair enough, I think, when you look at that decision, points to the court's focus on the role of natural resources essentially as commodities in giving rise to and sustaining armed conflict. So she also, and this is a quote from her, she says, well, there's just a failure to engage with, these are her words, the more subtle ways in which exploitation practices entail ecological degradation, loss of livelihood, and adverse social consequences. And she also points out that the decision conceals, these are her words, how the commodification of nature may generate violent conflict, and the way that the extractive industries, among others, indeed create the conditions for resource wars. Well, Eliana's book, published last year, was just, I think it preceded the decision of the court earlier this year on the question of reparations. So really the case has had two phases, the 2005 decision, and I'm summarising very generally, but the court then told the parties, go off and try and negotiate an agreement on reparations owed. The parties had to come back and said, we can't do that. So the court, obviously with reservations, that the court makes this clear in its judgment, delivered a decision just in April this year. And I think I'm free to talk about it because I wasn't involved at all in this. So all I know about the case is what I've read. So what I thought was really lovely in chapter 4 of the book that deals with international courts and tribunals, Eliana foreshadows this judgment and she raises a series of questions. She asks things, what would constitute adequate reparation for the plunder of natural resources? She's foreshadowing the questions that the court would have to face. Another one is, what about the loss of fauna and biodiversity? Can that loss be compensated for in monetary terms? And she also wonders, would the court award compensation for the damage caused by the extractive industries in the Congo, such as the degradation of land and water, the loss of livelihoods, and the destruction of intangible heritage? Well, I think, and I hope that Eliana will publish something on her analysis of the reparations decision in due course. But it was very helpful having Eliana's framework when I went to read the judgment. And those of you who've read it will know that the court, in fact, the judgment does pay considerable attention to reparation of the plunder of natural resources, as well as for damage to flora and fauna. Indeed, if you count up the number of paragraphs of the court's decision, I think the largest number are devoted to those questions. And we also know, because the report's available on the court's website, that the court commissioned an expert opinion on compensation for the loss of natural resources. So I think we could say that one important aspect of the decision just this year is the court finding that, certainly reaffirming an earlier decision, that international law allows compensation for environmental damage. But while the court held that damage to flora through deforestation could be compensated in principle, it didn't in fact award any damages for damage to the environment and biodiversity, really because of the failure by the DRC to provide adequate evidence. There was some, interestingly, the court did acknowledge the problems of gathering evidence in relation to damage to fauna or wildlife. And the court says, and I think it's quite an important statement, these are its words, that it will give particular weight to reports by international organisations specifically mandated to monitor relevant sites. And it looked at some of these reports. So this was information the court itself identified, not the DRC. And it did award damages, particularly for the loss of the okapi, these animals that are indigenous. They're well, mainly to the Ituri region in the DRC. But the court, while it seemed to go perhaps beyond what some commentators thought on that issue, it was very cautious about whether you could actually, an international court could give damages for macroeconomic damage. And the court seems to be calling for a direct nexus between the illegal use of force and the alleged damage. So I think reading the court's decision on damages through Eliana's framework, it's not difficult to see the limits of the judgment. There's certainly little apparent recognition of the slow and structural violence that is at the centre of Eliana's analysis. And I was struck by the fact that Eliana contrasted the court's 2005 decision with the approach of the UN Committee on Economic, Social and Cultural Rights, its 2009 concluding observations on the DRC. And she shows how that UN committee, that human rights treaty body, takes a much broader approach to illegal resource exploitation, for example, in acknowledging the involvement of transnational corporations in the environmental destruction. So I was chastened in a sense. I thought that was a very interesting lens, and I really enjoyed Eliana's close reading of these decisions. I think they're really perceptive and nuanced. And yet I was just going to reflect that since and working at the court and really leaving my academic environment, what I've become mainly aware of, and this is a point that Eliana makes very much, but it's just I want to reinforce it, the limits of international litigation. So I've become more and more struck by the fact that, at least in its contentious jurisdiction, the court's role is to decide a dispute as framed by the parties. So it's really restricted by the arguments that the parties put to it. And I must say, on cases I actually have sat on so far on the court, you're really aware that you're very much in the hands of the parties. So I've really had to sort of do quite a shift from perhaps a more academic perspective, a more scholarly one, where you're not constrained, where you can go and look at things. So just looking at the arguments that were put to the court in the armed activities case, it's worth noting that originally the DRC's written pleadings didn't make any claim in relationship to diversity, as distinct from the damage for the claim for damage from the plunder of timber. So it was very focused on, well, we can value the logs and so on, but there wasn't a greater claim made there. Eventually, in its final submissions at the end of the oral stage, the DRC did seek reparation for deforestation. But if one looks at the final submissions the DRC put to the court, it was really the claim for deforestation was much, much, much less, I think about 10% of what it valued the commercial losses for the plunder of timber. So the parties itself were putting forward this quite modest valuation. So we can see that it was the DRC itself that framed its claim for environmental damages in commercial rather than ecological terms. It clearly didn't have the advantage of Eliana's book to help it think those through. So, of course, the court in its advisory jurisdiction can take a broader perspective. But again, and I've not sat on any advisory opinions, but I'm very conscious in the jurisprudence of the court's very careful to respond to the precise question on which its advice is sought. So as international lawyers, I think we have to be very cautious about the capacity of particular institutions to achieve change. And this is something that Eliana astutely recognises at various points. So the court might be a prominent feature in the international legal landscape, but I'm constantly reminded how it's just one strand in a regulatory fabric. It's most effective when it's combined with other forms of regulation, such as mobilisation by civil society. So just to conclude, I think this book, if I may say so, beautifully reflects Eliana's personality as a scholar. It offers a really skillful technical account of international law on the environment and conflict. And it also gives the reader a sophisticated but wonderfully accessible introduction to theories of slow and structural violence and environmental justice. I think also in my experience with Eliana, this reflects her personality. The book is extremely gracious in its tone, deferential to the elders of the International Legal Academy, generously acknowledging their work while modestly pointing out the originality of her own work. But I think above all, the book is a wonderful testament to the insights that arise from interdisciplinary scholarship and how much international law stands to gain from this. I was once told by a wonderful professor of history in Australia that you never launch a book, you actually have to open it. So I'm delighted to join everybody in opening Eliana's book.
Right. Thank you so much. We turned to somebody else who has opened the book, I think, right? Sophie, to share your comments.
Put this on. Thank you so much for this invitation. It's been a really wonderful trip to read your book. And although I do not work on environmental issues myself, I felt really at home in your book. And that is because it's well written, because you can really see the craftswomanship of making an argument, making an consistent argument throughout the book. But I also felt at home for two reasons in particular. And one is that it took me back to my master's in conflict studies. It feels a while ago, but when I started reading about it, I was like, oh yes, coming home. So in discussing the environment as a source and a motor and a victim of conflict, your book goes back to Galtung and this distinction of negative and positive peace. And you warn us how international law has been cherry picking from conflict theory. And in so doing, it is missing out on a vast debate on the complexity of motives behind conflict that go beyond simply greed, and a more comprehensive understanding of violence beyond immediate, visible and physical damage. And I will admit that getting into law after conflict studies felt somewhat like a relief for me, because finally people were doing something. They were making clear rules instead of adding one set of complexities to another set of complexities, showing that conflict is actually really more complicated even than we already thought. But what your book shows is that the price you pay for simplicity is complicity. And the second reason why I really felt at home in your book is that I always really like a work that shows how international law is part of the problem. And I strongly endorse your call for embracing complexity, as you call it. When I read sentences like, and I quote here, reconciling ecological sustainability and militarism appears a difficult task for international lawyers, even the most progressive ones. I really enjoy those sentences, not because I don't like lawyers, but because I just really like scholarship that calls out international law's reductive power and provides the necessary counterbalance for its blunt savior complex. Eliana's book shows that international law has not ignored the conflict environment nexus, but when engaging with this nexus, international lawyers draw on and reinforce one-dimensional and problematic assumptions about nature, about violence, and about the intersection of the two. And as you argue, the choice of certain frames affects the type of responses, affects whose interests are protected and whose voices are heard. What your book reveals is how international law has been preoccupied with spectacle. International courts, the UN Security Council, truth commissions, all these fora in international law seem to be drawn to instances of direct violence, physical harm, recognizable core crimes. And the book is a plea to international law to start paying attention to slow and structural violence, as it's in the title. The violence, slow and structural violence, is violence that has no specific place and no specific time. It is the structural inequality at the root of conflict and the off-camera violence in the aftermath of the spectacle. And I quote from page 211. It's the contamination, pollution, loss of biodiversity, and ecological damage, which may deprive a country and its population of livelihoods indispensable for survival. And international law has been keeping structural violence carefully out of sight. And even when, in your words, structural and slow violence enter the picture, it is largely in the background. In other words, structural and slow violence remain in the context for real violence. What I learned from the book is that international law's response to the environment conflict nexus is based on a very narrow understanding of environmental violence, mainly focused on economic rationales and impacts, resource exploitation, economic loss and gain, ownership, greed, flaws in resource governance. And what I also take from the book is that international law's response is based on a very narrow, human-centered, individualistic understanding of nature. For international law, nature is a stranger, an object, the other. Nature can be rightful property or illegally obtained. It can be a military objective. It can also be a victim of conflict in need of protection, but it's always the other in service of humans. The paradise lost, that what we long for and take down in our desire to own, cultivate, protect, and finally destroy. So next to the two prominent visions of nature, you explicitly identify so nature as commodity and nature as a tragic victim. There's this other related prominent vision of nature in your book and recurring in international law. And that is nature as the exotic stage of violence elsewhere. The good old civilizing mission of international law is never far away when it finds the main locus of core crimes in wild, faraway lands where, and I quote from the Ntaganda case before the ICC, military victory is celebrated in the shade of the mango trees while the massacres and pillaging continued. In this way, nature, as the other, also facilitates the othering of the victims and the perpetrators of mass violence, of externalizing blame, feeding international law's savior complex. Nature as the other. It reminds me of a Dutch poet, Armando, who writes about the guilty landscape. In his poems, nature is a victim of mass violence, but also a witness and a collaborator. This I find an interesting thought experiment also when reading your book. What if we emphasize nature's complicity in violence as an actor? Would international law take it seriously then? What if we take the agency of nature to the extreme and make it not the victim, the means or the source of violence, but its perpetrator? In your book, Eliana, you cite Grotius, who called on man to not destroy or hurt cultivated plant or fruit trees, because trees cannot, as men may, rise up in arms against us. But what if they could? And not necessarily as an army of violent plants, like in the science fiction classic, The Day of the Triffids, which is one of my favorites, but more as a living being with whom we can share empathy or amity, like another science fiction, Ursula Le Guin's Forests, or less in the realm of science fiction, and I hope we hear more about that later, the more than human worlds and holistic approaches to nature that Eliana is also putting forward in her quest for embracing complexity. Nature as property or as a victim is in a way easier, makes it less important, less threatening to the deeply human-centered, power-hungry international law than nature with actual agency. Eliana points us to a recurring question in international law, which perfectly illustrates international law's short-sighted view on nature and violence. So this is the question. What degree of damage is legally acceptable in the pursuit of the necessities of war? It's almost absurd to me how the urge to protect the immediate survival of sovereign power trumps any long-term concern about the survival of the planet as a whole. But putting that aside, what if we let go of this innocence of nature, landscape, planet? What, for example, if we take the battlefield as an exquisite example of entanglement? Landmines, for example, depend on nature's cooperation to conceal their existence. When I was in Sarajevo, it frightened me how the landscape, the surrounding hills, made the scary success of the siege of the city much more tangible than the horror story staged at the ICTY. And now I'm also thinking of work in political science by Guillaume, Anderson, and Fiore on color and camouflage on the battlefield, on how they describe how, for example, artists were hired in the First World War to not only produce camouflaged clothes and vehicles, but also, for example, fake trees. How blending in with nature is as much part of the pragmatics of warfare as distinction. Nature is the combatant's closest ally, or when it does not cooperate, its fiercest enemy. So where am I going with this? I guess it's simply to endorse the point that Eliana is making so sophisticatedly throughout the book. How, especially in the context of conflict, and I cite, international law reproduces the artificial separation between humans and nature and the deeply rooted view of nature as property or object to be appropriated, dominated by man. So where do we find some relief? Where IHL and ICL might be too pragmatic, too simplistic, too militaristic. You also know that international environmental law may be, on the other hand, too aspirational and too vague. And you propose to resort to environmental justice, feminism, intersectionality, interdisciplinarity, and I think that's all really great and a very good idea. And you plea for a revaluation of nature's intrinsic value and humanity's deep entanglement with the non-human. And a solution might not lie in acknowledging nature as a victim of conflict or as yet another living being with rights, because then it will yet again be the other. And international law is very good at othering, taking away agency, ignoring structural inequality. And the question for me is, can it ever be capable of addressing slow violence when its foundations are so squarely at odds with appreciating the out of sight, the more than human? Can international law indeed embrace complexity? Well, at least you can, Eliana, and that is why everybody should read this book. Thank you very much.
Would you mind if I stand? I feel like sitting is really my writing position. I want to reach out to my pen. And I also need to, I have slides. I don't know.
Yeah, they put it on.
Magnificent. Does this work?
Great, thank you so much, Sophie. It was wonderful. We're working on the slides. It's happening. Awesome.
I'm not used to working with this. Does anyone? Ah, yeah, it should be on. Ooh. Voila. Thank you. Wonderful. So let me start by thanking Eliana for inviting me to this wonderful panel today and to stress what a pleasure it has been to read and to think with you, Eliana, about the ecology of war and peace. I would like to use the next 10 minutes to present and share 4 main gifts that reading Eliana's book offered me. First, a reflection about what it means to think of the ecology of war and peace against the backdrop of the Anthropocene. Second, a reflection about what it means to grieve for ecological loss. Third, a reflection about more than human ecologies. And finally, a reflection about contemporary entanglements between ecology and war, in relation first to Ukraine, inevitably, and second to Anthropocene ecological calamities. And for all these reflections, I found inspirations in authors to which I will refer to on the slides, which act as a collage of literary references and visual support for their main interventions. I thereby want to put Eliana's wonderful book in dialogue with thinkers from other fields, domains, and traditions in order to further expand the reach of Eliana's work and the debates it enters to. The journey on which Eliana embarks its readers is an invitation to think about ecology in relation to war and its aftermaths, and the role international law plays in invisibilizing ecological harms in times of both war and peace, and the slow, precarious, and fuzzy transition from war to peace and from peace to war. What is then the ecology of war and peace? The word ecology has, of course, a different meaning than the environment or nature, and refers to a matrix of relations that binds living entities with the complex infrastructure of the environment. The key term here is relationality. A rupture of one relational link invariably produces other effects across the broad spectrum of entities that constitute a given ecology. Is the ecology of war the same as the ecology of peace? Are we speaking about the two sides of the same coin, or does one necessarily exclude the other? What Eliana's book shows is that the discipline of international law is ordered by ideals and dynamics of war and peace. And if nations united in the second half of the 20th century to maintain international peace and security, Eliana's book shows that wars are not a state of exception, but recurrent calamities that differentially affect human and non-human beings and communities. How then can we conceive of the ecology of war and peace if, as Jairus Grove has argued in the book Savage Ecology, War and Geopolitics at the End of the World, warfare, or the homogenization of organized violence, underpins, organizes, and characterizes the contemporary global order, an order that Eyal Weizman has redefined as a weaponized environment. What happens to the imagination, not only of international lawyers, when we take Grove's invocation of war as a form of life seriously? What would it mean to consider warfare as a form of life? That is an ordinary practice for many people, rather than the ways we often characterize war as an anomalous or rare event that suddenly breaks out. For many, indeed, as Eliana shows, warfare is already an embodied reality rather than an abnormal break, where jus in bello is written into the very musculature of bodies, social practices, and communities. Does this imply that we need to adapt even more our legal language to this warfare, as in the war on climate change, the war on the pandemic, the war on the virus, at the risk of perpetuating the Schmittian friend-enemy distinction that has come to pervade political and legal imagination, a trend that feminist theorists like Donna Haraway, Isabel Stengers, and Anat Singh carefully invite us to suspend and question? This feminist sensibility and caution also transpires in Eliana's book, which she invokes as providing, and I quote, the intellectual tool to move beyond a militarized and state-centric approach to peace and security. To take just one example, where insights from feminist theory and the attention paid to embodied affects play a role in Eliana's book, one of her main claims is to show how theories of greed, as the motivation for starting and prolonging armed conflicts, have attracted much attention in scholarship, while the dynamics of ecological grievance have received less attention. How do grievances over natural resources access and distribution pave the way to armed conflicts? Eliana asks. The turn to affect that Eliana invites us to contemplate, to feel, to embody, opens up multitude of overlapping forms of grievance, ecological, but also socioeconomic, political, and historical ones. Leslie Head, in her book on hope and grief in the Anthropocene, extends the practice of grievance to the underacknowledged process of grieving, which also aligns with the state of war as a form of life mentioned earlier. Grievance, grief, and loss might well become our emotional companions, as they have long been those of the marginalized and the poor that Eliana draws attention to, following Rob Knox. How then can attending to such emotions illuminate different pathways for understanding the remaking of worlds in the midst of violence? Loss requires mourning and grieving for the destruction of a relation and those subjects that are constituted through that relation, Catherine Yusuf insists. Yet international criminal law, international humanitarian law, international environmental law, and international human rights law might not be attuned to such loss, grief, and mourning of both a collapsed ecology and of those inhabiting it. Worse, they reinforce a profound sense of disconnect between the two. As Eliana observes, and I quote, "International law fails to appreciate the entanglement with non-human beings and reproduces problematic assumptions about human domination over the environment." Might it be that, as Gary Simpson argues, and I quote, "International law is one large project of sentimental solipsism, advertising its virtues and obscuring its vices." Clearly, we are left with a form of depoliticized sentimentality that perhaps is most visible in the way we passively assist to international law's complicity in managing the extinction of forms of human and non-human life at times of both war and peace. Eliana pays particular attention to this sense of detachment and reflects on how international law performs a particular understanding of how humans are disconnected to non-humans and the non-human world more broadly, which is captured as a property, a commodity, a resource to be protected, looted, commodified, bordering war and peacetime. She also points to the necessity of expanding the analytical frame of what she calls the environment and conflict nexus, as well as the notion of the environment victims of war beyond the human, to account, and I quote again from Eliana's book, for non-human concerns and redefine the relationship between nature, conflict and peace, and humanity, so that forms of structural and slow violence are made visible. The third point of reflection that I would like to attend to is therefore Eliana's invitation to take seriously the obligation owed to non-human beings in times of war and peace. And to this end, Eliana contends that, and I quote again, "entirely new ways of framing and interpreting international law are required." As argued by Joseph Pouliez, indeed, more than human victims of war and colonialism are entangled with and subject to the same regime of saturated violence. Bringing the more than human world into the purview of justice reveals a new political and legal ethics where the more than human offers itself as an imperative to rethink the anthropocentrism of international law, as Eliana points out. So far, I briefly drew attention to what an ecology of war means against the backdrop of the Anthropocene, about what it means to grieve for ecological loss, and about justice for more than human ecologies. Now let me turn to the last, my final point, a reflection triggered by the wonderful book that Eliana offered us, namely an invitation to focus on slow and structural violences of contemporary wars that she coins new wars. And what new war to focus on today, if not Ukraine? Indeed, the war in Ukraine presents us with an entirely new, slow and structural violence, revolving around this ecology as a weapon of war, where war is fought not for, but through energy policies. Ever since the invasion of Ukraine, the economic sanctions imposed on Russia as a key extractive power in the raw materials economy, and the indirect effect of these sanctions on the energy and food supply of Russia's clients' economy, has opened the space for a new ideological and economic mobilization discourse. This rhetoric revolves around the turn towards energy sobriety as a means for peace. The rationale behind this ecology of war is that the energy dependence on Russia indirectly finances Putin's military enterprise, making us, as individual consumers, complicit in the war. The mainstream discourse on energy sobriety invokes at once the imperative of coercion against the Russian war machinery and the imperative of reducing greenhouse gas emissions, thereby breaking with the toxic dependence in geostrategic terms and in terms of climate policies. As these pictures shows, the principles of political ecology are not simply adjusted to the time of war. They are redefined and subordinated to the imperative of conducting war, integrated into a logic of confrontation in which the enemy is both the source of geopolitical destabilization, and the holder of the toxic resource. The war ecology emerges as an ideological relay for the war economy. Yet the flip side of the coin is that fossil fuel extractions are reactivated to compensate for energy losses, as seen with the Netherlands, Austria, and Germany reverting to coal power only this week. But this is not the only contemporary new war with a peculiar and novel ecology. Indeed, the entanglement of war economies and war ecologies are also at stake in the slow and structural violence that unfold from Anthropocenic calamities that today redefine the very contour of inhabitable space. Sea level rise, floods, droughts, locust swarms are only some of the ecological disruptions and reconfigurations of livable space that will inevitably fuel tomorrow's wars. And against this backdrop, Eliana's outstanding book, The Ecology of War and Peace, will really act as a cardinal coordinator to orient, or rather reorient, and attune the ecology of international law to these new modes of living and coexisting at the crossroad between war and peace. Thank you.
Thank you so much, Marie. There are a lot of suggestions already on the table. Questions, perhaps, a lot of praise where it's due, of course. But maybe you already want to pick up some of those or add your own take, or perhaps even a retrospective after 1 year since you sent in the manuscript. Eliana, please, your opportunity to react.
Yeah, thank you. I think this is okay. Wow. So let me start by saying how beautiful this was, and how grateful I am for Hilary, Sofia, and Marie's engagement with my book. It's been a true delight to listen to your words, and of course, Hilary, Sofia, and Marie's own research has been an inspiration for myself on issues such as, of course, violence, human nature relationship, the value of critique, visibility. So of course, I mean, just to name a few. So I really want to thank you, and of course Ingo as well, for taking the time really to read my book and to participate today. And of course, this is, I think, the best book launch that I could have hoped for. So it's really fantastic. And I'm also quite overwhelmed by all your comments, and I'm so happy that this has been recorded, so I can actually go back and really take the time. And yeah, really, this is a lot. I mean, it will be, of course, impossible for me to react to all the wonderful and insightful, valuable comments that you have made. And also will take me a long time also to actually process all the, everything you just said. So I only have a few minutes. And so what I thought I would do is to just say a few words, perhaps on how this book came about, the concerns underpinning it, of course, I mean, in relation to what you just said, the intervention that I'm hoping to make. And this, as I said, might resonate with a number of points that, of course, you raised in your own comments. So arguably, international law as a discipline and as a practice has been concerned with violence and war since its modern origin. And post-colonial scholars have indeed argued that violence is indeed foundational to the discipline of international law. And equally foundational to international lawmaking is human relationship with nature. And yet until only quite recently, the intersection of nature, conflict, and peace has received attention in legal scholarship only quite recently, yes. So becoming kind of a niche area of research and practice. And this is, for instance, testified by the International Law Commission inclusion of this topic within its work. And also, of course, the cases and the jurisprudence of international courts and tribunals. So in that context, I think this book seeks to speak to different audiences. And I don't know if this is a good or a bad thing, but anyway, being a book about the law, it's of course primarily for
lawyers, researchers, students of international law. And within this field, it hopes to be of interest to the enthusiast, to the skeptic, and to the cynic international lawyers. So one quite simple objective of this book is, of course, as you have pointed out, is to show the internal and external limitation of any inadequacies of the law in tackling questions of environmental justice. And so what I hope more traditional lawyers get from it is, of course, is a better sense of the limits of our field, as well as the opportunities that come when we are pushed outside our comfort zone and we engage with other fields of inquiry, and not really to find answers to our problems, or not even to solve or to save international law, but really to actually ask different questions that may kind of inspire alternative engagement with some of the most pressing challenges that we are facing. And instead, of course, of rushing to the search for a solution, perhaps we should just pause, take a step back, and reflect, of course, on the implication of legally defining certain problems in certain terms. And for those that are already familiar with the set of critique, of course, this book hopes to illustrate through a series of case studies how the ecology of war and peace can actually be the entry point to reflect on the biases, the contradiction, the complicities of the field. And so it will hopefully illustrate how international law is actually a background condition of possibility. It's involved in promoting specific visions of what is good, what is peace, what is security, and also what is justice. So often legal academics are pitting doctrinal work against theoretical work as if the two are antithetical and antagonistic. So I guess many of us are on Twitter nowadays, and I was really struck by this, you might, of course, you know, Maria Aristodemou. She's a prominent scholar, and I'm sure you also inspired your work as well. And she said, no, she said this that really struck with me. The whole point is that the relationship is dialectical. Neither doctrine nor theory remain the same after the encounter, and all the better for both. And so that was really kind of encapsulating my approach in this book. So this book is concerned about silences, of course, in the discipline and practices of international law, but is also examining how erasing forms of structural and slow violence, ecological violence, is a window to understand the role of law in reproducing inequality and injustices, violence and conflict. So how does international law create the condition for resource wars to break out? How do we make sense of the tension in the field between militarism, warfare, on the one hand, and ecological sustainability on the other? Those points were raised, of course, in the previous comment. What is the role of the law in presenting both ecological preservation and devastation as legitimate aims under the existing legal framework? So all these points were, of course, made. Commentators. So those, to answer those questions, as it has been said, I try to move across disciplinary boundaries, look at theories that have influenced international legal discourses and practices. I would say this is my first intervention. And I engage, as it was said, with a rich debate in peace and conflict studies, theories such as the environmental security, the resource curse theory, environmental peace building, but also concepts such as natural resource scarcity or abundance. And the aim, of course, is somehow to show how those concepts and theories are indeed contested, and they often reflect anthropocentric or colonial stereotypes, but also how they have fed into international law and shaping how the ecology of war and peace has been discussed, approached, and addressed so far. And so, as it has been said, I look at different institutions, courts and tribunals, UN Security Council, Third Commission, and as it has been pointed out, one thing that I, for instance, show is that how this grid thesis has been very successful in international law, so successful that it paved the way to a number of interventions like Security Council sanctions, like the adoption of new legal frameworks such as the Extractive Industry Transparency Initiative, or also a decision by international courts and tribunal, like the case of the Congo-Uganda case, the armed activity case. And of course, the assumption implicit in these normative measures is that once the promise for gain is reduced, the conflict will somehow die out. Unfortunately, that's not the case. And as other scholars have showed, by failing also to consider how poverty, inequality, and marginalization are also part of the stories of this conflict, this normative intervention may actually be counterproductive, leading to the revival of old grievances and creating new ones. So this, of course, raises question about the function of international law, not only in silencing and distracting, perhaps, but also in reproducing the very problems that it seeks to address, as I mentioned before. And it was mentioned, of course, by the panelists. And this would be my second intervention. And the third one, which was also interestingly, I mean, of course, we haven't talked to each other before, but the third intervention that I'm making, of course, is to try to illustrate the different conceptualization of nature in relation to conflict that underpin rules governing war and transition to peace. And so this case studies also reveal how legal norm preserve nature as a public or private property, over which man exercises dominion, as an economic asset to be protected from the excess of war. And more recently, of course, the idea of nature as another victim of war or humanitarian concern has emerged. And you can see echoes of this discussion also in the debates around ecocide, which is a more recent and topical, perhaps, issue. So, but even when framed as a victim, environmental degradation is acknowledged as a tragically unavoidable sacrifice in relation to the larger objectives of war. So it's a casualty. So of course, this doesn't mean that we don't have rules and principles. And of course, I'm really looking at those rules and principles in my book. But it means also that, as the panelists have noted, international law struggles to reconcile the ethical justification for preserving nature with the pragmatic logic of militarism and warfare. And this raises the question of whether there can ever be a reconciliation between those two logics. So I would stop here, and before handing over to Ingo, I wanted, of course, to thank again to the panelists. This was absolutely fantastic, and also I wanted to thank the ASSER event team, and in particular Eileen for for the support, and Elisa from the Amsterdam Center for International Law for making this event happen. Thank you.